So when a tragedy strikes, who can actually sue for being injured? It's one of the toughest questions in the legal world. But what if that injury is something you can't even see?
To get into this, we have to go back to a day that started with all the excitement of a huge sporting event, but ended in, well, a national tragedy. The date was April 15th, 1989. The place? Hillsborough Stadium.
And the human cost, it was just staggering. Because of a catastrophic failure in crowd control, 96 men, women, and children lost their lives in a horrific crush. But, the horror of that day didn't just end with the people who were physically trapped in that crush. For all the friends and family watching, some from other parts of the stadium, others glued to their TVs at home, the psychological trauma was just beginning. And this brings us to a really deep legal question. Can you sue for an injury when you weren't in physical danger yourself?
Okay, so to really get our heads around the court case that came out of this, we've got to understand the sheer scale of the event itself. So let's take a closer look at the Hillsborough disaster. So this was a massive deal, a huge FA Cup semifinal in Sheffield. The crush itself happened in these overcrowded spectator pens. And here's the real kicker. The whole thing was being broadcast live on TV. That meant millions of people were watching the chaos unfold in real time, and many of them had no idea they were watching the last moments of their own loved ones' lives.
And that right there, that brings us to the very heart of this legal fight, the unseen injury. You see, the law has always had a tough time figuring out what to do with psychological damage, or what it officially calls psychiatric harm. This case is so important because it really nailed down this legal idea of a secondary victim. Now, this isn't somebody who was actually in physical danger themselves. No, this is someone who suffers a real, recognized psychiatric illness just from witnessing a horrific event. And the people suing in this case, they were all secondary victims. All right, so let's talk about the actual people who brought this massive case to court. It's known as Alcock versus the Chief Constable of South Yorkshire Police. They were all relatives or friends of the people who died that day. And when you look at who was suing, man, it was just a heartbreaking list. You had parents and spouses who were right there in the stadium, but in different sections, totally powerless. You had siblings at home staring at the TV, frantically scanning the crowd for a face they recognized. And then you had others who only heard about it later and had to go through the unimaginable task of identifying a body hours after it was all over. So you can see how this put the court in a really tough spot. I mean, if they let all these people sue, where do you draw the line? Could anyone who watched the news and got traumatized file a lawsuit? It's what lawyers call the floodgates argument. This fear that one decision could open the door to a million other lawsuits that would be impossible to manage. One of the judges, a guy named Lord Keith, he put it perfectly. He basically said, look, for the good of the system, the law has to draw a line somewhere. And a huge part of his reasoning came down to the TV broadcast. He pointed out that the cameras showed general chaos, not the specific suffering of any one person you could identify. And for the court, that little detail made all the difference.
So, to fix this problem, right, to stop those floodgates from bursting open, the highest court in the land at the time, the House of Lords, came up with a really strict three-part test. And what they came up with is now famously known as the Alcock control mechanisms.
It's a three-part test. First, you had to have a close tie of love and affection with one of the victims. Makes sense. Second, you had to be physically close to the event or its immediate aftermath, not hours later in a morgue. And third, and this last one, this was the real hurdle for most of the people suing. You had to have seen or heard the event with your own unaided senses. Watching it on TV, that didn't count. The effect of this decision was huge, and honestly, it left behind a really difficult legacy that people still argue about to this day. It drew a very, very hard line in the sand. And the result? Well, it was pretty black and white. The law said a duty of care, that's a legal duty not to harm someone, was owed to people who were directly involved, like the police officers on the scene. They were called primary victims. But for those secondary victims, like the brother at home watching in horror on his TV, the court basically said, sorry, no duty of care here, because they failed that strict test. So here's the bottom line. The Alcock case decided that, legally speaking, the shock you get from seeing a tragedy on television is different from the shock of being there in person. That TV screen, it basically became a legal wall. And all of this leaves us with a really tough question for today. I mean, you have to remember, this ruling came down in 1992. In our world of nonstop live streaming and instant news from our phones, where a tragedy can be broadcast up close and personal in real time, does a legal test that's all about proximity and your unaided senses even make sense anymore? That's a question the law is definitely going to have to face again.